Domestic violence charges. Are you facing domestic violence charges in Texas? Hi, I'm Jeff Hampton with the Fulgham Law Firm, and I want to welcome you to our YouTube channel. Here today we're going to cover domestic violence. What's the law say in Texas about domestic violence? Is there a way to defend your case? By the way, if you wait around till the end of this video, I'll also give you a free ebook, What to Do If You've Been Charged with a Domestic Violence Crime in Texas. Okay, let's jump right into this. Now listen, being charged with a domestic violence crime, particularly if you didn't do anything wrong, it's very scary. It's an intimidating situation. And so people get into this situation and there's all these things that are associated with the charge: emergency protective orders, no contact orders, all these things you can no longer do. You lose certain rights at the moment you become charged and you get booked into jail. You also have to wait for a significant period of time before you see a judge and you receive your bonding instructions. So one of the things we look at here is what can be done, what specific strategies exist in order for you to be able to defend a domestic violence charge in Texas. Now, one of the things that, despite the fact that there was quite a bit of domestic violence reform in Texas over the last 5 to 10 years, it's important to understand that a good, experienced criminal defense attorney still maintains quite a bit of discretion, and there are a number of different things available at the disposal of your attorney that can help you to be able to defend the charges. But before we do that, I think it's important that we identify what are the charges. What does Texas law say about domestic violence? Well, I'm going to march you through it real quickly just so that you have a better understanding about what the law says, okay? Number one, let's examine perhaps what some people call the most minor of those charges is assault by contact family member, okay? So the state of Texas, under this charge, must prove beyond a reasonable doubt that you intentionally or knowingly contacted the alleged victim in a manner that was offensive. That's what the law says, offensive. Now, this is a Class C misdemeanor. Now, some people say, well, that's not a big deal. It's a ticket, right? Well, it is. It's a citation. The temptation is to say, well, it's no different than a speeding ticket. So I'm going to just go down here and I'm going to pay the ticket, and why does it matter? It's not a big deal. Here's the problem. If it's an assault by contact family member case, the state of Texas has recently enacted laws that will require you to go down, be fingerprinted, and entered into a database of family violence offenders. So if you go down and you pay the fine, you're now convicted, and it's permanently on your criminal record. So this is a big deal. In the past, because there was no arrest and you were just given a citation, it wasn't as big of a concern, but now that you can be put into a database, even for a citation, the same level as a traffic ticket, it's important that you resolve that case in a way that you can get it expunged from your criminal record. All right, now the next type of offense we're going to talk about is assault bodily injury. And this is assault bodily injury of a family member. This is a Class A misdemeanor. It is punishable by up to 1 year in the county jail and up to a $4,000 fine. What does the state have to prove? The state of Texas must prove beyond a reasonable doubt that you intentionally or knowingly contacted the alleged victim in a manner that caused pain. Now, I keep doing all this stuff because I'm telling you, it's a little in the eye of the beholder. What does it mean to be offensive? The previous charge I was talking about, what's offensive to you might not be offensive to someone else. What about pain? People say, well, how do you prove pain? Well, pain literally means, ouch, that hurt, okay? Well, how do you prove that? Well, someone can just claim it hurts, but many times what people look for is some type of actual proof of that, bruising, marks, something that shows that there was an actual injury that took place. But it's very important to understand injury must not be proven. It doesn't have to actually be shown that there is actual bruising or any type of physical proof of an injury in order for it to be shown up in court. Now, here's the thing. If there is no proof of physical injury, though, that becomes a pretty weak case. Having been a former prosecutor for 5.5 years, I can tell you, whenever I had a case that came across my desk and I saw that there was literally nothing wrong with the individual, I've even seen when police officers would take a picture of someone and I'm looking at it going, I don't see anything. There's nothing there. It looks like a regular arm. Well, if that's the situation, it creates doubt, okay? And if there's doubt related to the case, it creates potential leverage for your criminal defense attorney to be able to go in and hopefully get a positive resolution to your case. All right, now let's walk our way up the ladder of ascending seriousness when it comes to domestic violence. The next one is an assault impeding breath of a family member. The state of Texas must prove beyond a reasonable doubt that you intentionally or knowingly contacted the alleged victim in a manner that impeded the circulation of their breath. Many people refer to this offense as an assault by choking. It is important to remember that the state of Texas cannot prove that the alleged victim was unable to breathe as a result of, if they cannot prove that they were unable to breathe as a result of that contact, then the charge is not going to be supported in court. Now, the reason why I say that is there have been situations where I've had clients where the person we represent walks up to the alleged victim, puts their hands on their chest, or maybe even puts their hands up by their neck, and they panic and they freak out. But then later on, after they're actually interviewed, they said, no, I could breathe, but I was very upset that they put their hands up by my neck because I thought they were going to choke me. There must be actual proof that their breath was impeded in order for it to be a felony. Failure to make that proof shown can actually drop the charge down to a lesser charge from a felony down to a misdemeanor. Because the reason why I say that is assault impeding breath is a third-degree felony, and it is punishable by up to 10 years in prison and up to a $10,000 fine. Now, there is a new law that's in effect in the last 10 years called continuous family violence. Continuous family violence is a third-degree felony, punishable by up to 10 years in prison and up to a $10,000 fine. And under this offense, the state of Texas must prove beyond a reasonable doubt that you intentionally or knowingly assaulted the alleged victim 2 or more times within a 12-month period. This is important. So many times what happens is someone will make a claim and then they'll say, oh, hey, 8 months ago, that person did that to me too, okay? Well, 8 months later, there's many times no real proof of that other than the person's word. If the state of Texas is unable to prove one of those assaults, then the entire case must be dropped down to the lesser charge of a Class A misdemeanor domestic violence, okay? Now we move our way up, and this is the last one I'll talk about on this point, is aggravated assault of a family member. An aggravated assault of a family member is a second-degree felony, punishable by up to 20 years in prison and up to a $10,000 fine. Here, the state of Texas has to prove that you intentionally or knowingly contacted the alleged victim in such a manner that caused serious bodily injury or a deadly weapon was used in the commission of the crime. Now, what do we mean by serious bodily injury? Serious bodily injury is any type of injury that causes a permanent loss of use or a protracted loss of use of a bodily member or organ. So let's say you broke your arm and you can never use it the same way again. Maybe you're crippled. Maybe your face is disfigured. Maybe there's brain damage. Those are examples of serious bodily injury, okay? Now, let's talk for a few minutes about some of the defenses. One of the things I hear all the time, people come in and say, but I was charged and I didn't do anything wrong. I didn't commit domestic violence. What kind of defenses should I be looking at here? There's got to be a way to beat this case. Well, number one, generally, there's the defense of mistake. And what do I mean by that? Well, a victim of domestic violence who has generally, when they've been victimized by someone, they're aware of who the person was that made the mistake. But not always. Sometimes you can have instances where someone was involved in a particular instance, but they're not exactly sure who the person was if there were multiple parties involved, and there may be some confusion over that issue. But I want to talk more about the information is itself mistaken. And what I mean by that is, think about this for a minute. Let's say a family member is very upset. Let's say two people get very upset at each other, a boyfriend and girlfriend, all right? They get upset at each other and then police are called. Well, the police come out, pretty much assure you, if it's a domestic violence call, somebody's going to jail or they're going to be getting a citation of some sort because the police are going to show up and they're going to be afraid to leave people by themselves and leave the scene, okay? So it's human nature, though, that you're going to perceive things in an exaggerated manner when you're upset and controlled by your emotions. So what happens is if I'm upset at someone and someone comes and asks me, hey, what just happened? Well, if I'm still upset and angry, I'm going to perceive that in a different way than when I talk about it 5 hours later or the next day later. That's just human nature, okay? So let's say you combine that with that information being shared with a police officer. And let's say that person's still angry. And now the officer is asking questions like, yeah, that hurt, didn't it? Well, that's okay. It's not a big deal. A lot of yes or no questions being asked. That information's being written down. It doesn't take very much evidence to establish probable cause to arrest someone for a crime, particularly domestic violence. So, I just think back on times in my life where how many times did I say something when I was upset that I regretted? How many times have all of us been misinterpreted? How many times have we looked back and said, that's not fair, and I want to make sure I'm not being unfair to someone just because I was angry? And so the next question that comes up is, okay, well, what can happen? If that's true, what if that applies in my case? What types of steps can I take if my case is based upon mistaken evidence? Well, here's the first question. If the alleged victim does not want to prosecute your case and they're willing to come forward and reveal what they were thinking and clarify what actually took place at the time, it's important that that alleged victim gets in touch with your criminal defense attorney, and there are some steps that can be taken to mitigate this process. And what I mean is there is something under the law called an affidavit of non-prosecution. An affidavit of non-prosecution is a form that allows the alleged victim in a case to provide evidence to the state of Texas. It's literally a valid piece of evidence, just as legitimate as a police report or a video. And if the alleged victim is eager to provide this information, then it can provide reasonable doubt and provide you a footing for your defense. Now, here's where this really comes into play. If it's a felony, what if your domestic violence case is a felony? If it's a felony, the affidavit could actually be presented as a packet to the grand jury, and it allows the grand jury to review your evidence and make a determination of your case. If it's a felony and they think the choking element can't be proven, they may lower it down to a lesser charge of a misdemeanor. If it's a felony and they believe that not only was there no choking involved, but there was no actual assault involved at all based upon the statements now provided in this affidavit, your case could be what's called no-billed. And a no-bill under the law is basically the same thing as your case being dismissed, and it allows you to be eligible to have it expunged from your criminal record. Now here's the next one, okay? Not just mistaken evidence, that's number one. Number two, my family member is lying. Now, listen, sometimes whenever people get heated, particularly in a divorce situation or a child custody situation, you can sometimes run into people making false allegations. For what purpose? What's the motive? We see people do it all the time in an effort to control the outcome of a heated custody battle or the outcome of a divorce situation. So often there's some very specific things your attorney needs to do. First thing they need to do is go over the alleged victim's statement thoroughly. And what I mean by that is identify the time, the place, the facts of the allegations against you. And then we need to investigate some text messages, emails, phone calls, any other types of communications that the alleged victim made to provide context behind the story, okay? To be able to determine whether or not it even makes any sense. What about collecting witness statements? We've had situations where we've had an actual client that was involved in a situation like this, and there were witnesses that were with the alleged victim right before and right after this so-called time frame that this happened, and everything that happened with these other people didn't make any sense. It doesn't match up. It didn't match up with the alleged victim's statement. If that is the case, it once again can create reasonable doubt, and it should be examined and investigated by your criminal defense attorney. Okay, now, here's another one. We've had this happen a few times. Your third defense can be you have an alibi. Now, so when people start lying about things and they start claiming things happened at a certain time and place, many times you can provide hard evidence of an alibi. And what do we mean by hard evidence? Pictures, text messages, digital proof of location are examples. We had a client one time where this woman claimed that our client had assaulted her, and they were exes. They had been together in the years past, and he had pictures of himself with 3 other people at a baseball game, and they were taken, they were time-stamped, they were posted. And we had all of that there, and he had the ticket, everything showing hard evidence that he wasn't there at the time that she was claiming. And so this evidence would provide proof that the alleged victim is either lying about the incident or certainly not being totally forthcoming about actually what took place. Either way, it provides a strong defense for you if you're facing domestic violence charges. Finally, what about this one? What if you did commit domestic violence, but you didn't, and I've had people say this, but I didn't mean to? Well, here's the thing. Sometimes if someone is guilty of domestic violence, there are still some things that can be done mitigation-wise to even possibly get your case dismissed. One of those is called diversion programs. There are domestic violence diversion programs. As an example, in Tarrant County, here in Tarrant County, Texas, in the Fort Worth area, if it's your first offense for domestic violence, you may qualify for the Tarrant County Domestic Violence Diversion Program. It's basically a program that if you get into it through your attorney's assistance, upon completion of a lengthy rehabilitation program, essentially you're going to what's called a batterer's intervention program. You complete that program, and they change the names of those sometimes, but it's essentially a rehabilitation program. And at the end of the program, here's the payoff. Your case is dismissed. You could still be eligible for an expunction after the statute of limitations has lapsed. So I tell people this all the time. There is a way to handle these things. If it's your first offense, even if you've done it, you've made a horrible mistake, with the right attorney, there are some options where it doesn't have to ruin your life in the future. Now, the last thing I want to tell you is this. Many people say, well, can't I just take deferred adjudication probation? What if I just take probation? I'll be okay, right? It's not a conviction. No. Taking any plea deal other than it being dismissed or dropped down to a citation deferred will result in this being on your permanent criminal record for the rest of your life. So it's very important that you make sure and deal with an attorney who specializes in this area. And we at the Fulgham Law Firm do exactly that. So if you'd like to learn more about this, first of all, if you like the video, I encourage you to click the like button on there, subscribe to our YouTube channel. But I also want to be able to give you an opportunity to have a free case analysis. If you'll contact the Fulgham Law Firm at 817-877-3030, we would be happy to give you a free case analysis and a consultation. And I promised you if you waited around to the end of this video, I'd give you a free ebook, What to Do If You Have Been Charged with a Domestic Violence Crime in Texas. Click the link below. We'll send it right over to you. Thanks again for joining us today. Thanks for being patient with me. I hope this information has helped you. We'll see you next time.